There have been several distinguished guests announced today. I'd like to announce one more. Kelly Townsend, the Majority Leader of the Arizona House of Representatives, is with us. She was also recognized by fellow state legislators around the country last year. The state of Arizona hosted the first National Convention of States that has been held since 1861, and Kelly Townsend was elected president of that body. I also would like to, since he's not here, give you a character reference for Nicholas Cole. Some of you already know him and have worked with him. I'd like to tell you something that you may not be aware of. I have a cousin, had a cousin. She and her husband were professors at Oxford University, and Nicholas was one of her students. I met Nicholas in my cousin Miriam's living room in Oxford in 2005, and again in 2011. Earlier this year, Miriam relapsed into leukemia and lay dying in the hospital over a period of several weeks. Nicholas repeatedly came to her bedside to watch her and to look over her. She was not his relative, but she was his friend and his teacher, and someone who had recognized him for someone who was great and good. Those of you at Utah State University who have chosen to work with Nicholas have chosen very well. The question is what the future of federalism is. I would have to suggest to you that unless the state legislatures exercise the primary function, the primary check given them by our founders for the preservation of federalism, that the future of federalism is grim. To introduce this, I want to mention a case that some of you may have heard of. It's a U.S. Supreme Court case. It just came down in May, called Murphy versus NCAA, National Collegiate Athletic Association. The case was widely publicized in the media as a victory for federalism. The case involved the constitutionality of a federal law called the Professional and Amateur Sports Protection Act. It has an acronym, as all federal laws do these days, PASPA. The purpose of the Professional and Amateur Sports Protection Act was to essentially stamp out sports gambling. The act included a grandfather clause for states that permitted sports gambling, at least to a certain extent. But it also had a provision which stated that no state may authorize sports gambling in the future. That is to say, Congress decreed that no state legislature may pass a law loosening its regulations on sports gambling. The question before the U.S. Supreme Court was whether this particular provision violated a doctrine of the court that you heard about this morning called the anti-commandeering doctrine. Did an order from Congress telling a state legislature that it could not pass a particular law violate the federal system as enshrined in the Constitution? The answer, in a 7-2 opinion given by Justice Alito, was that the Professional and Amateur Sports Protection Act was unconstitutional, that it did violate the anti-commandeering doctrine. And so that was the basis of many people reaching the conclusion that this was a huge victory for federalism. In the course of the majority opinion, Justice Alito included the following sentence, which we lawyers call dicta. That is to say, it was not required by the dispute before him. The dictum was, quote, Congress can regulate sports gambling directly if it elects not to do, but if it elects not to do so, each state is free to act on its own. Congress can regulate sports gambling directly, but if it elects not to do so, each state is free to act on its own. In the two-person dissent, Justice Ginsburg did not really quarrel with the conclusion that the anti-commandeering doctrine had been violated. But she included the gratuitous comment, nor is there any doubt that Congress has power to regulate gambling on a nationwide basis. There was only one justice who objected at all, and did so only weakly, to this statement about the power of Congress to regulate gambling on a national basis. And that, it may not surprise you to know, is Justice Thomas. But 8 members of the court, essentially without the requirement of the case before them, opined that Congress could regulate gambling on a national basis. The problem with that is that if you are aware of the balance that the founders drafted and inserted into the Constitution, is that the statement is false. Gambling is not, according to the great English commentator William Blackstone, commerce. Furthermore, a substantial number of advocates of the Constitution, and this fact is not widely known, a substantial number of advocates to the Constitution, in order to drum up popular support for the Constitution, in order to induce ratification, convention, delegates to vote for the Constitution, made explicit representations to the public as to the kinds of powers that were outside the scope of the federal government, except, of course, within territories or the District of Columbia. Among the powers that they firmly represented as outside the power of the new federal government were education, social services, local roads, and a number of different powers having to do with gambling, such as debt collection, private contracts, regulation of morals, and others. There is no reasonable question from the historical record that issues of gambling, except insofar as they might involve the sending of tickets to interstate commerce, were reserved to the states. But in fact, the U.S. Supreme Court has signaled that in this area, as in so many others, state jurisdiction may be unilaterally impaired by the federal government. The federal government, I need not tell you, regulates and legislates in virtually every area of American life today. I want you to think about a world where we had a United States Constitution and we had a First Amendment, and that the First Amendment protected, in its terms, protected freedom of speech and freedom of religion and freedom of assembly. But in this world, unlike ours, the courts never enforced those restrictions, ever. That if Congress did in fact pass a law violating freedom of religion or freedom of speech, the courts didn't strike it down. Would we really have freedom of speech, freedom of religion, etc., in such a world? No, of course not. Congress would be forever testing the limits and would be forever constricting what were the protections of the First Amendment. I want you to imagine another world. It's one in which, while the president has a veto in the Constitution, the president never exercises this veto, ever. When a bill goes through Congress or threatens to go through Congress that the president doesn't like, he remonstrates against it. He uses the bully pulpit against it. but he never actually vetoes the law. What would happen to the president's power under those circumstances? I suggest it would shrivel away to almost nothing. Constitutional protections are meant to be used. And the provision in Article 5 of the U.S. Constitution, which empowers the states to require Congress to call a convention for proposing amendments, is a provision that was meant to be used. And moreover, not just used, it was a provision that was meant to serve as a primary buttress of federalism. And so I ask you to imagine a world in which that provision was never used. What would the federal-state balance look like? No, we are in that world, aren't we? And it goes a long way to explaining why the federal government has gotten so big and the states have gotten so relatively helpless. At this particular conference, the Federalist Papers have been quoted a number of times. I would be the last to minimize the influence of the Federalist Papers or the importance of the Federalist Papers. They were enormously important and remain enormously important. But the fact is that they're not the only thing that was written during the founding era, and they're not the only representations, they're not the only explanations of meaning that were issued by advocates of the Constitution and opponents of the Constitution during the founding era. If you've ever read the Federalist Papers, unless you're like me and you get off on reading 18th century English, you will discover they're difficult. They're really difficult. And the usual explanation for that was, well, they knew how to read back in those days. No, actually, the founding generation folks had a lot of trouble with them too. They were mocked as dry and inscrutable. And so there were other advocates for the Constitution that wrote material that was more accessible, that was easier to understand. And there was one gentleman in particular whose writings were at least as influential with the general public as the Federalist Papers, and his name was Tench Cox. Tench Cox was a friend of Alexander Hamilton. He was our first Assistant Secretary of the Treasury. He was a member of the Confederation Congress, and he was a prolific and tireless advocate for adoption of the U.S. Constitution. One of the arguments against the U.S. Constitution was that once we get it, we can never change it. Tench Cox wrote the following: "It has been asserted that the new Constitution would be, when ratified, would be fixed and permanent, and that no alterations or amendments should those be proposed, appear on consideration ever so salutary, could afterwards be obtained. It is provided in the clearest words that Congress shall be obliged to call a convention on the application of 2/3 of the legislatures, and all amendments proposed by such convention are to be valid when approved by the conventions of the legislatures of 3/4 of the states. It must therefore be evident to every candid man that 2/3 of the states can always procure a general convention, that means a national convention, for the purpose of amending the Constitution, and that 3/4 of them can introduce those amendments into the Constitution, although the President, Senate, and Federal House of Representatives should be unanimously opposed to each and all of them. Congress therefore cannot hold any power which 3/4 of the state shall not approve on experience." Tench Cox was not the only person who emphasized that the convention procedure would be a way of dealing with federal abuse or federal overreaching should it come. One can make the argument, since, well, what percentage of the people approves Congress? I think it's something like 6% think that Congress is doing a good job. I actually never met any of these 6%, but they say they're out there, right? The view among the founders was if Congress became dysfunctional or abusive, it was this process which would be used. In another point, and for those of you interested in action at the state level, I want you to consider this carefully. This is Tench Cox again speaking. Before we dismiss this point, it will be necessary to attend very particularly to one more fact relating to it. The sovereign power of altering and amending the Constitution or supreme law of the American Confederacy does not lie with this federal legislature. That power, which is truly and evidently the real point of sovereignty, is vested in the several legislatures and conventions of the states, chosen by the people respectively within them. The federal government cannot alter the Constitution. The people at large, by their own agency, cannot alter the Constitution. But the representative bodies of the states, that is, their legislatures and conventions only, can execute these acts of sovereign power. From the foregoing circumstances results another reflection equally satisfactory and important, which is that as the federal legislature cannot effect dangerous alterations which they might desire, so they cannot prevent such wholesome alterations and amendments as are now desired, or which experience may hereafter suggest. Let us suppose any one or more alterations to be in contemplation by the people at large or the state legislatures. If 2/3 of those legislatures require it, Congress must call a general convention, even though they dislike the proposed amendments. And if 3/4 of the state legislatures or conventions approve such proposed amendments, they become an actual and binding part of the Constitution without any possible interference of Congress. If then, contrary to the opinion of the 8 adopting states, the federal government should prove dangerous, it seems the members of the Confederacy will have a full and uncontrollable power to alter its nature and render it completely safe and useful. 2/3 of the states, 3/4 of the states have that power. They've always had that power. If you complain about what has happened to the federal-state balance, it is because they have never used that power. Let me just finish by mentioning one or two other things that might be on your mind. When Representative Townsend chaired the Phoenix Convention of 2017, she was not in an unprecedented position. She was the president of a long history of interstate conventions. We have not had a convention specifically for proposing amendments under Article 5 of the Constitution. But we have had, on a recurring basis in our country, conventions of states and colonies dating back over 300 years. A convention of states, of course, proposed the U.S. Constitution. A convention of states proposed the Constitutional Convention, the one meeting in Annapolis in 1786. Conventions of states during the Revolutionary era dealt with issues of defense, inflation, trade, and other subjects. In 1814, a convention of New England states met to propose amendments to the Constitution. In 1861, a general convention of states met to try to stave off the Civil War. In 1889, another convention of states met to deal with monopolistic practices in the meatpacking industry. In 1922, a convention of states to which this state was a party, and the great state of Arizona was a party, met to negotiate successfully, under the chairmanship of Herbert Hoover, the Colorado River Compact. A convention of states to which this state was a party subsequently negotiated the Upper Colorado River Compact. There is a long and honorable history of states meeting together in their sovereign capacities to solve common problems. Some have been successful, some have been less than successful, none have run away, but all of them have been an important part of our American constitutional system. Let's make them an even more important part of our American constitutional system. Thank you.